Welcome to my YouTube channel, Legal Information, Law Insights. I am Advocate Mukund Mahajan. In this video, I will explain an essential concept in civil law, the difference between issue of fact and issue of law under the Code of Civil Procedure, 1908, CPC. Understanding this helps every civil litigator, law student, and litigant comprehend how courts arrive at decisions. Section 1. What is an issue in CPC? Let's begin with the basic question, what is an issue? As per Order 14 Rule 1 of the CPC, an issue is a point of dispute between the parties in a suit, either on a matter of law or a matter of fact. Issues are framed after the pleadings are complete. The court identifies disputed propositions of law or fact that need to be adjudicated. For example, plaintiff says the defendant borrowed 10 lakhs rupees and did not repay. Defendant denies borrowing the amount. This disagreement gives rise to an issue of fact. Issues help the court focus the trial, guide the evidence, and ultimately reach a reasoned judgment. There are three types of issues. 1. Issue of law. 2. Issue of fact. 3. Mixed issues of law and fact. Section 2. What is an issue of law? An issue of law is a point that requires the court to interpret or apply the law. It does not require factual proof. Instead, it requires understanding how the law applies to admitted or proven facts. Examples: whether the suit is time-barred under the Limitation Act, whether the court has territorial or pecuniary jurisdiction, whether a particular notice under Section 80 CPC was necessary, whether a suit is maintainable under a statute or barred by a statute. These issues are generally decided by the judge alone, based on statutory interpretation and legal precedents. Evidence is not necessary to decide a pure question of law. When an issue of law can dispose of the case entirely, the court may decide it first to save time and cost. Judicial reference. In Birla v. Steel Brothers, the Supreme Court said courts can dispose of suits on pure legal grounds without recording evidence if the issue is capable of deciding the matter finally. Section 3. What is an issue of fact? An issue of fact arises when the existence, truth, or relevance of a fact is disputed. This includes disputes about actions, behaviors, events that need to be proven or disproven through evidence. Examples: did the defendant actually sign the contract? Was the plaintiff in possession of the land on the date of filing the suit? Did the defendant commit breach of contract? Was the notice properly served? These issues require oral and documentary evidence, including witness testimony, cross-examination, expert reports, if applicable, documentary proof. The judge examines the evidence, weighs credibility, and delivers findings on each fact. Order 20 Rule 5 CPC says the judgment must state the decision on each issue separately, along with reasons. Real-life example. In a property dispute, the plaintiff claims adverse possession for 12 years. The issue of fact is, was the plaintiff in continuous and hostile possession? This must be proved by evidence, not just pleadings. Section 4. Mixed issues of law and fact. Some issues are not purely factual or purely legal, but mixed, involving determination of facts followed by legal interpretation. Example: in a defamation suit, the court must determine whether the defendant made the statement, fact, whether it qualifies as defamatory under law. Another example: in motor accident cases, whether the driver was rash and negligent, fact, whether it fulfills legal requirements of liability under the Motor Vehicles Act, law. Mixed issues often require a full trial, combining witness examination, application of statute or precedent, judicial observation. In Makan Lal Bengal v. Manas Bhunia, the SC explained that mixed questions demand detailed analysis and cannot be decided by legal arguments alone. Section 5. Framing of Issues Order 14 CPC. Under Order 14 Rule 1, the court frames issues after going through plaintiff's plaint, defendant's written statement, documents and admissions. These issues are framed at the first hearing once pleadings are complete. The issues guide. What evidence needs to be laid? What legal arguments are needed? How the judgment will be structured? If an issue is not framed, the court cannot decide upon it unless parties agree or raise it during the trial. Key point. Issues must be material, i.e., relevant and necessary to resolve the dispute. Section 6, Order 14 Rule 2 Priority of Trial. Earlier, courts would decide pure issues of law first and postpone others. But after the 1976 amendment, Rule 2 says, all issues law and fact must be decided together unless a pure legal issue can dispose of the suit entirely. This avoids fragmented trials, delay, and wastage of resources. Example: if the suit is barred under Section 11 res judicata and this can be proven without evidence, the court may decide this issue first. Section 7, Landmark Case Laws, with citations. Let's revisit three major judgments. 1. Union of India v. Ibrahim Uddin, 2012, 8 SCC 148. Reiterated that courts must record findings on all issues and that appellate courts can interfere with findings of fact if essential facts are ignored. 2. KK Birla v. Steel Brothers, AIR 1976 SC 2439. Held that issues of law can be decided at the outset if they may finally dispose of the case. 3. Makhan Lal Bangal v. Manas Bunia, 2001, to SCC 652. Clear differentiation between issues of law, fact, and mixed questions, especially in election petitions. Section 8, Practical Tips for Lawyers and Litigants. Understand the difference to strategize effectively. Focus legal research on issues of law. Prepare witness list and evidence for issues of fact. Ensure pleadings are complete. Incomplete pleadings is equal to incomplete issues is equal to incomplete justice. Raise preliminary legal objections early, if they can dispose of the suit. Always request the court to frame specific issues, this can shape the entire outcome of your case. Conclusion. To summarize, issue of fact is equal to dispute over what happened needs evidence. Issue of law is equal to dispute over what the law says needs interpretation. Mixed issue is equal to needs both. Framing and understanding issues is the foundation of any civil trial. Thanks for watching this video. If you found it informative, please like, subscribe, and share your thoughts in the comments. Don't forget to hit the bell icon for more legal insights. I will meet you in the next video soon. Jai Hind. Jai Bharat.